However, as per the communication dated 5/3/2025, bracket annexer P15, the post is not available. Vacant post is not available, even though there was an interim order in the writ petition directing the post to be kept vacant. Issue notice.
That is in respect of assistant director.
We have not, you must carefully listen. We have not specified in your submission that for which post is to be kept vacant. Just by issuing notice, be happy.
Oblige.
Yes.
So this is that matter where
That matter that now there is nothing.
What is there?
Oh, it is not an order.
You know, your lordship.
Whenever there is an order, you will be granted liberty.
Correct. So that is what the High Court holds against me.
No, High Court has not given liberty. We will grant you that liberty. High Court has not granted liberty. We will grant you that liberty.
I have, in my years before this honorable court, noticed I can't get out in a way. Your lordship,
Having heard
of the matter is
having heard on counsel for the parties and the observation made by and the finding recorded by the High Court that the order dated 11/4/2018 passed by the managing director.
Please. This is
the communication dated 11/4/2018.
Administrator and SDO.
No, it is said managing officer Ulhasnagar.
Page 60 it says administrator Ulhasnagar City Settlement and Subdivisional Officer.
Page 68.
It's 60%.
By the administrator Ulhasnagar City Settlement and Subdivision Officer Ulhasnagar, is not an order amenable to revisional jurisdiction under section 24 of the Displaced Persons bracket Compensation and Rehabilitation Act 1954, we are not inclined to entertain this SLP. However, it is observed that as and when any order of adverse to the interest of the petitioner is passed, he will be at liberty to avail the remedy as per law. Yes.
But may I make one request? The initial observation where your lordships are making that observation that your lordships are not inclined to hear my petition. That if your lordships feel it suitable, maybe it's true. The last liberty may be kept. The petition, I'm seeking a disposal of my SLP because the proceedings will start again. All the grounds that I have taken here, they will say that you've gone up, and this is how administrative authorities deal with. So the first line only, when your lordships are saying not inclined to interfere, that if
not inclined to entertain.
Well, that's only one. Only what I'm only requesting is this: your lordships may say that we are dismissing the SLP. However,
we are not trying to entertain the SLP. However, yes.
Grateful. No, it's all questions of law. All contentions are left.
Yes.
Very great. It's very deeply.
Not against the.
All contentions raised by the petitioner in this SLP shall remain open to be agitated as and when occasion arises.
Very deeply.
Yes.
The High Court in the most callous manner has quashed the FIR. Will you kindly see page 36?
That's what
is that Vyapam?
Vyapam, ma'am.
No.
Will
1 second.
Notice.
No, 1 second.
Notice will go.
My lords, I may. No, my lords. What my learned colleague is not informing your lordships.
No, we have seen that.
No, my lords. What
SLP is dismissed, we have seen that.
No, what is not being informed is same, my lords, by same common order.
2 different years. These are 2 different years, 2 different RCs.
If
learned
ASG, my lords, permits me, my lords, to address this court for 1 minute. There is one common order of 16th May 2025. In that common order, my lords, both the matters are covered. Now, my lords, what CBI does, my lords, is that, my lords, as a matter of strategy, They file, my lords.
High Court, there is no scam. Nothing has happened.
No, my lords, only this person. Please see, my lords, please see the order. If your lordship sees the order, my lords, it is only, my lords, past
Here you file.
the facts. No, my lords, what I am saying, it is already covered.
No,
my lords,
I am personally satisfied that this is a case worth. Read the papers. It's a case worth notice.
so, my lords, what I am submitting, my lords, is
Conducted a trial.
No. What
Mini trial.
Mini trial.
with respect, my lords, what I am submitting is that so far as I am concerned, there is already a finding, my lords, in 16th May order, and that 16th May order was brought to this honorable court,
file counter
and the
is
SLP, my lords, same order, my lords, there cannot be two situations. If your lordship just sees, my lords,
In 6
Ah.
weeks, no.
if
Yapon
your
matter, we know.
my lords, against same order, my lord, there may not be, my lords, two different, my lords, observations from the honorable.
Annex it
Court.
in your counter.
Please see, my lords. Please see, my
No.
lords, the same order.
There's a delay.
Go and accept notice.
There's a delay, my lord.
Yes, they condone.
My lord, I'm asking to stay because they are asking parity in other matter.
Stay,
Notice on stay also, my lord.
just notice on stay. Stay we are not granting.
Please,
Not
no,
hearing.
notice on stay.
Yes.
Item 73.
Please, madam. My lord, kindly see page 16. Page 16, my lord.
अरे लोगों के घर हम गए हैं 30 साल से लगे हैं.
My lord,
Who are you?
your lordship, I am.
Deposit 1 crore will issue notice. Deposit 1 crore will issue notice.
Your lordship, if
अरे allotment हो गया 1995 it is allotted. People are staying there, in constructed their houses, and you want them to be evicted now in
your
2026.
Ram Pradhan has allotted land, kindly see
Dismissed
page
with
16.
cost of rupees 1 lakh.
Kindly, your lordship, kindly.
Dismissed with cost of rupees 1 lakh.
Then,
Go and settle your scores in panchayat and election.
then your lordship, kindly, yeah, I'm seeking to withdraw.
No, dismissed as withdrawn. Yes.
Item 31.
Yes. Lordship, say affidavit has been filed by the state that only one witness remains.
Minutes and sitting of weeks time, minutes the Agri Council has some personal difficulty. It's a request.
The remaining witness will also be examined.
Only one witness.
One is remaining.
Yes, Lordship.
Minutes, it's a request, minutes just adjourn it for 1 week.
Why?
Minutes, there is some personal difficulty with the Agri Council. Minutes.
And Lordship, there is also.
I filed the affidavit, there only one.
Learned State Council informs that affidavit has been filed stating that only one witness is remaining to be examined in the trial. Para. Learned Council for the petitioner prays for time post on Monday.
Lordship.
Obligation.
Yes.
Item 32.
My lord, in item 32, I have filed an impediment application, my lordship. And item 32, I have moved an impediment application, my lord. I am the main complainant in the matter, my lord. My lord. Oh, my lord, my lord may allow my impediment application and I may be allowed to file counter affidavit, my lord.
Because I appear
What
for
counter?
the state. My lords, I appear for the state. I want to put some facts to the records. My lords, they have been threatening the witnesses. My
That
lords.
lady is threatening the.
My lords,
My-
FIR.
My lord,
My lords,
My lord, FIR is there.
My lords,
My lord,
FIR.
my lord,
lady is threatening.
my lord, her husband, my lord,
This lady is.
my lord, may I?
My lords,
Her
the name is
cancellation,
there.
seek cancellation of her bail.
My
My lord,
lords,
we have done. My lord, we have done that.
Why on
You have done that.
The lady should be allowed.
No, my
my
lord.
lords, the cancellation of bail has been filed. My lords, in one of the FIR, even her name is mentioned, the petitioner's name is mentioned. If I may just bring on record the documents, my lord. My lords, may just see if I can just pass the FIR. My lords, may just allow me 1 week's time. My lords, they have also lied on the affidavit. My lords, she's not 67, she's 65.
Yes, my lord.
My lords, it may not be that big of a difference, my lords, but they have been threatening.
65, how does it matter?
My lord, they are
They're
threatened.
tampering with the
If it remains
investigation.
pending
Charge
for
sheet
1
has
month
not been
more,
filed.
she will be 69.
My lords,
In Supreme Court, the age grows.
I understand, my lords. My lords, the charge sheet has not been filed. They're tampering with the evidence, the witnesses, they're threatening them, my lords.
Yes. How many persons have died? How many persons have died?
My lords, it is not.
Not a case of death.
But the charge sheet, my lords, till the time the charge sheet has not been filed. My lords, may just allow me 1 week's time. My lords, I'll put on the entire facts, then my lords may see.
At the request of State Council, post after 2 weeks, interim to continue.
My lord, impleadment may be allowed. Impleadment of, for the complainant, my lord. I have moved.
Implement allowed.
Item 33.
Yes.
For item 33, I'm appearing for the petitioner, my lords.
Yes.
My lords. My lords, in terms of the interim protection granted, my lords, I have already also joined the investigation, my lords. All the main co-accused persons have been released on bail, my lords. The charge sheet has also been filed, my lords.
You have
I was
seen
not-
counting money in the video.
Yes, my lords.
Yes, my lords. My case is, my lord, that I am a young laborer who was working on the
Yes,
horse
joint
farm of the
investigation.
Joint investigation, my lords, but only the difference between other accused and the present accused is that, my lords, 3 have been given regular bail and the 4th one was given anticipatory bail because, my lords, he was not named in the FIR and he was only named in the disclosure statement. But, my lords, in addition to that, he has been found in the video, my lords, that has been produced by the complainant, my lords. And rupees 2,40,000 comes to his share that is to be recovered, my lords.
Recovered from him.
My lords, because they have distributed the share among themselves, my lords, and
420 only.
yes, my lords. It's a trap they played,
Considering
my
that
lords. Innocent
after the
person was trapped.
petitioner was granted interim protection by this court while order dated 5/1/2026. He has joined investigation. We are inclined to make absolute the interim order. Accordingly, it is directed that in the event of petitioner's arrest in relation to crime number so and so, police station so and so, for offences under section so and so, the concerned IO of the trial court shall release the petitioner on bail on such terms as may be imposed.
And he shall cooperate in the investigation, my lords, because charge sheet has not been.
Shall cooperate with the investigation
As
and
and
the
when
trial as well.
my lords.
Yes.
My lords, one just humble submission, my lord, the cost of 50,000 imposed by the High Court may also be waived off, my lords.
The cost of 50,000 imposed on the petitioner is set aside.
Very much obliged.
If granted, set aside here, no?
Obliged, my lords.
Yes.
Item 34.
Very much obliged.
Lord, by this petition, Lord, I am seeking anticipatory bail to the petitioner, Lord, on the ground that the
16-year-old girl.
16
16-year-old girl. The girl is 16-year-old.
16-year-old, but
And you are seeking anticipatory.
My lord, on perusal of the paper book, Lord, I have no role because the prosecutrix has been examined under section 163 and 163, my lord, kindly see page number 26, page annexure P2. And sir, annexure P3.
Page number?
180, page 26, my lord.
26. Yes.
He is a co-villager, my lord. He has no role in the case. And Lord, kindly see at the bottom, my lord. Kindly see the relevant portion at the bottom. I and Ijaz used to talk from last 2 years on 12th of June 2024 when no one was present at home. I and at 11 a.m. running away from the house went to Sugauli railway station, from where I reached Anand Vihar railway station by boarding in Sapkranti train. And I called Ijaz. I have come here, and who came at railway station to take me. Then we came to the, he took me to the Nazafgarh, where we stayed 5 full days, and Ijaz had to go to Mumbai for doing job. And then we both went to Mumbai and stayed till 2 months. Then we came to Muzaffarpur from Mumbai to marry in court. And on 20th of September 2004, we got married in court. Thereafter, we again went to Mumbai. On frequent call my parents, I alone came at Motihari, and 17th of October 2024, I married. I remained in the Motihari railway station, and in the morning I came at Sugauli by train and coming to the police. In the meantime, I brought to the police station by Sugauli. So there is no role, my lord, of the, see, there is no allegation. Now, my lord, kindly see a statement of the prosecutrix at page number 28, recorded under section 180, my lord. So they are now thereafter, annexure P4 as per the order of this Child Welfare Committee, she is residing with the Ijazul because she has attained the age of majority, my lord. So in this case, I am.
What is your role according to the prosecution?
Ji, my lord.
According to prosecution, what is your role in the office?
No role, my lord. Kindly see, my lord has read the statement. No role, because I am a co-villager. I have been only named to pressurize to bring the girl. Now the girl has been brought by the police, and 2 times her statement recorded, my lord. Kindly see page number 28 also, under section 180 BNSS. In that statement also, she has not named me.
FIR, where is the FIR?
In FIR also, my lord, my name is my name is mentioned in the FIR, but there is no allegation against me. Kindly see page number 24, my lord. Munna Dewan is the father of the Riazul and Sehnaz and wife of Munna. I am Tawfiq Alam. But in the contents of the FIR, my role is not mentioned, my lord. So he is absolutely innocent, my lord.
No, you are involved in kidnapping at the stage of kidnapping.
Kidnapping, but my name is not there.
Your name is there.
Kidnapping, as per the contents of 163, my lord. Kidnapping is made out only under section 363, only when the she is kidnapped from the lawful protection of her guardian. But as per the statement of the prosecutor,
He is 16 and you have kidnapped. That is in the
she
FIR.
has left the protection of her guardian and went to
Read paragraph, page 25. So and so, so and so, so and so, including you, have kidnapped my daughter.
Name is mentioned, and
Have kidnapped my daughter with
kidnapped
intention
my
of marriage.
daughter with intention of marriage, and I went
Doing
to
that
their
since
house,
16 less
not
than
in my house, my lord.
Considering that
Not in my-
this
I
person
am-
is named in the FIR as one of the person who has kidnapped the victim aged 16 years, we are not inclined to.
But now, sir, she is living with her husband.
Maybe. Yes. Next.
Item 70.
Yes.
Yes, this is regular bail marriage. I've been in custody for
Yes. Notice.
9 months.
Notice returnable in 4 weeks. Post on. You have been granted anticipatory bail in one case.
In one.
And this is the second case.
This was the second.
There is dispute about the control of that
It's the
association.
management of the society.
And you are in jail since last 8 months.
More than 9 months.
9 months.
And I have medical conditions also.
Learned Learned counsel for the petitioner, learned senior counsel appearing for the petitioner submits that the petitioner is in jail for last about 9 months
9 months and 20
for an allegation for offense under section on the allegation of misappropriation and forgery of records.
But it's not misappropriation actually.
Forgery is also there.
Forgery is there. Forgery.
Concerning of records of the, what is that association? SPCAB? SPCAB? What is the full form?
Bijapur Women's Socio-Economic and Cultural Association.
Bijapur
Women's CBAC is the one, it's the short.
SECAB.
My lord.
What is this?
BAC.
What is this full form?
This is Bijapur Women's Socio-Economic.
Starts from S.
And yes, my lord.
What is Bijapur and S?
Yes, my lord. It's Socio-Economic and Cultural Association of
Socio-Economic and Cultural Association
of Bijapur.
Of Bijapur.
My lords. Registered under Mysore Society's registration.
Registered under Mysore Society's Registration Act
1960.
1960.
My lords.
It is further argued that in an earlier FIR, petitioner has been released on anticipatory bail, and the dispute is mainly about control of the above said association. Issue notice. returnable in 4 weeks. 4 terms.
Would my lord consider giving his liberty to serve the standing council?
Yes, liberty to serve standing council. Yes.
Item 71.
Grateful. My lord is giving returnable date.
Yes, some date is mentioned, maybe 18, 19 March something. Yes,
It's a legal aid matter, my lord. There's a delay also, my lord, at the outside. I must.
yes,
But there's a delay of about 11 months, my lord.
Yes.
He was in prison. But his offense is quite gruesome, my lord. However, my lord, he has undergone at around 9 years and 5 months, my lord.
you argue the appeal, you have committed murder of your wife.
My lord, that is the allegation, my lord. There is no direct evidence which relate me to
The
the
inside house, who will get it?
I was not there, my lord. I was not there, my lord. It is all recorded, my lord, there. It is not considered by the High Court.
Considering the entire practice of the case, we are not inclined to entertain this SLP accordingly. Accordingly, the SLP is dismissed. However, liberty is granted to move application for expediting the hearing of the appeal in the High Court.
Like,
Yes.
74.
Please, your lordship.
Yes.
Just seeking anticipatory bail, my lord.
Yes.
My lord, his name is not mentioned in the FIR. No role is attributed to him, my lord. Only on the statement
What are
of
you
A5,
doing?
my lord.
You are the kingpin.
No, my lord. No, my lord. Kindly see the FIR, my lord.
What the court has
A2
mentioned?
My lord, A2 is the operator. A1
You are the
is,
kingpin. You run the entire brothel.
my lord,
You are
kindly see.
running. You are managing the entire show.
My lord, the charge sheet does not say so, my lord. Kindly see the charge sheet at page 36.
It is already filed
Yes, my lord.
against you.
Not against me, but the role they have.
Surrender and apply for regular.
My lord, kindly see the charge sheet. There is no role, my lord.
Running a brothel and then coming to
My lord,
dismissed.
the owner of the premises has already granted anticipatory bail by the High Court, my lord.
Owner is not a kingpin.
My lord, the operator is also granted a bail.
Owner is only receiving rent for
My lord, if your lordship see the FIR, my lord, A2 is the operator of that brothel, my lord.
not inclined. In such an offense, not inclined. Yes.
78.
Yes.
May I please, Lordship? Lordship, this is a matter.
Head injury, serious head injury.
Lordship, this is
Serious
all
head injury and you are claiming anticipatory bail.
Lordship, this is all fabricated story. Why I'm saying Lordship, there is no material evidence on record to show that time of Isha there was a fire injury. Lordship, it is a long-standing rivalry between the two parties since 2021 over the land. Lordship, the petitioner filed the complaint in 2021, and we were directed to leave 3 feet of the land. Lordship, till today.
Thank you. Dismissed.
Lordship, may kindly.
Not a case for anticipatory.
Lordship, all three have been granted anticipatory bail. Lordship, other co-accused person have been granted bail. Lordship, there is no.
Where is that order?
Lordship, may kindly see page 3. Lordship, everyone.
Where is that order of anticipatory bail of the accused?
Lordship, yes.
Co-accused.
Lordship, may kindly see page 3.
Order. Show us the order.
Lordship, kindly see page 3 of the impugned order.
We want that order.
Page
We want order, not reference.
Lordship, order. I am.
In the same order?
Yes, Lordship. Page 2. Insofar as other petitioners are concerned.
No, they have no role.
Lordship, allegations are omnibus in nature. Lordship, all they have raised the allegation that all were involved. Lordship, there's a cross FIR also. There was a small scuffle between the neighboring families.
Thank you.
Lordship, may kindly consider.
Yes.
I joined the investigation. Lordship, may kindly grant me protection.
No. You have.
Lordship.
You have fired upon a person causing head injury and you say anticipatory bail?
Lordship, there is no fire injury. Lordship, this
Yes.
is all fabricated.
Call the next case. Yes.
35, my lord, the children are on record, but I have to serve them. Trustee may be permitted as the children's guardian. Lordship,
Is that compensation matter?
yes, my lord. The High Court, we were willing to give compensation. High Court increased the compensation and also did not quash it.
Let petitioner serve the children of the.
Yes, my lord. Trustee may be permitted, my lord, I'll serve them, my lord. We found
children of the respondent number 2.
Yes, my lord. We have found the children, my lord. They are.
Because respondent number 2, my lord,
Yes, ma'am. We pleaded.
got remarried and she left. The respondent number 2 got remarried and she left the children.
Yes.
We'll serve Trustee on the guardian of the children.
Let petitioner serve the children of respondent number 2.
Who are already on record.
We provided the correct address also, my lord. We just have to serve them Trustee, my lord. process was not filed. I'll file the process and serve Dasti on that.
Let fresh process for serving the children of respondent number 2 be taken. Full stop. Dasti is also permitted.
Great.
Post on 5th May.
My lords, in 36, I beg to appear on behalf of respondent number 1. I also seek some time to file my counter affidavit in this matter, my lords. The state has already.
I appear for 225 official respondents, my lord.
What happened to the proceedings in the High Court?
My lords, there is no stay.
They are adjourning it only because it is pending here, my lords. There is no stay on that, but they are adjourning it. It is now listed on 19th.
Lord, there is a stay by this honorable court. I appear for the petition.
What happened in the main proceedings in the police station?
My lord, in that we have called the respondent. He has been asked to appear before the IO along with some documents.
You complete the investigation.
We'll do that, my lords. The writ petition seeking quashing is pending, my lords. This SLP is only against the interim order whereby notice was issued. That's it. It is not.
Lord, your lordships, while passing interim orders, indicated that investigation will go on. In fact,
Lords may have page number 1, my lords. The only one-page order, my lords. Notice was issued and stay was granted on the investigation. Against that only they have come here, my lord.
And that too was only valid till next date of hearing, my lord. It was not a blanket stay which was provided on
Correct, my lord.
investigation.
So you want that writ petition to be infructuous?
My lords, I appear for the official respondent's statement.
Yes,
my
you
lord.
want that writ petition to be infructuous?
No, my lords.
While the petitioners are informing that the SLP is pending over here, we have not been, the petitioners herein are informing that.
What is preventing you in, you see, High Court stayed the investigation.
Correct, my lords.
We have stayed that order.
In persons of that, my lords.
We to investigate.
Correct, my lords. In persons of that, my lords.
You are helping the accused.
No, my lords. We have
Why
started
are you investigating?
My lords, we are investigating, my lords. I filed
let the respondent.
If I may submit, my lords, I have stated in my counter also that has not come on record. That was filed.
Why do you say that we are waiting for the outcome of the?
No, my lords.
In the High Court. That was your statement, Mister.
I'm sorry, my lords, if that has been conveyed in that way.
Let the investigation be completed within 4 weeks from today.
Please, my lords.
And charge sheet shall be filed before the.
My lords, but it is a civil nature.
Competent court.
My lords, it's a dispute which is of civil nature. Only the amounts have been.
We know charge sheet means let the investigation be completed within 4 weeks.
My lords, because.
Very deeply obliged.
And final report be filed.
Please, my lord.
My lords.
Before the competent
I'm grateful, my lords.
court.
Deeply obliged, lords.
Yes.
37.
May please. The state has not filed the response. The private party has filed. Lordships had granted me an interim protection.
Yes.
On the first date of hearing. The state's answer will be relevant in light of the material that was placed, but where it was subject to what the lordships feel.
Please, my lords, I appear for the state. I'm seeking 1 week time to file the counter. Because there are some transcripts between the complainant and the petitioner that I want to bring on record that shows cruelty, my lords, on the face of it.
Let the file counter.
I have no difficulty.
2 weeks time is allowed to Lorded Council for the respondent state of Rajasthan for filing counter affidavit. Yes, next.
Interim orders.
Interim to continue.
I am obliged.
के बाद 74 कहाँ से आ गया?
Well, in item 74.
अच्छा TP. Yes.
Well, I appear on behalf of the petitioner wife, Melody. Services complete notice has already been issued, Melody, on 15th of December.
Complete respondent is not appealing. There are other cases pending in Faridabad.
Well, 3 cases are pending.
Yes, allowed.
Grateful, Melody.
42.
Yes.
I am appearing a petition. It is coming after notice. Trial court record has been received. I want to inspect that record.
What?
A trial court record has been received. I want to inspect that record.
Which record?
trial court record, my lord. It is coming after
Trial
notice.
court.
It is a matter of appeal.
Counsel for the petitioner post after 4 weeks.
Fresh members complete.
Provide me digital copy of a record which is received.
Is allowed to peruse the trial court record.
But let the registry supply me digital copy of a
In
record.
the meanwhile, parties may obtain record of the digitized copy of the trial court record. Yes.
Very much obliged.
Should I call the Passover matters? Fresh matters completed.
Lords, in this matter we are. Lords, in this matter we are being led by.
We'll take the Passover matter of the fresh matters first.
Item 16.
Lord, where is the Passover, my lord? No, my lord, please.
My apologies, Lord, I'm sorry. I thought that Passover will be taken up at the end. But here, undoubtedly, Lord, sorry.
Yes.
I'm sorry. But here,
yes,
undoubtedly, Milords, a person has died, and we have Milords utmost respect for that. Cast an obligation, Milords, on the municipal board with a 70 lakh liability, with nobody virtually seeing the accident, Milords. And then, Milords, in appeal, staying that on 50% deposit.
You're only against interim order.
Yes, I am against an interim order. Milords, I am saying this. Two things. A, that not this 50% deposit should also not be there, because this is an exceptional case where none of the witnesses produced on behalf of the plaintiff have witnessed the incident themselves. Everyone, Milords, is giving a same typographical version, and ultimately it comes on record that his head has perhaps hit the divider driving without a helmet. Now, be that as it may, Milords, your lordships have held that there can be an exceptional situation where, Milords, a decree, money decree can be stayed without any condition. That, Milords, is a judgment, Milords, which is referred in the synopsis as well, in an exceptional case. However, nobody has witnessed the accident. Nobody. And to put the liability that... I'm sorry.
Total amount is.
But about 70 lakhs, 66 lakhs is the compensation. That is also till.
In the meanwhile, operation of the impugn order shall remain stable.
Item 19.
Yes.
Yes, the only piece of evidence is the dying declaration, which is made to PW1 manager, who happens to be the sister-in-law of the deceased. And when it's the dying declaration.
There are so many witnesses who have, before whom this oral dying declaration is made.
Well, that is what is my submission, that this dying declaration is made while the deceased was in the hospital. So when it's where the doctors were available and all the system could have been triggered for recording a valid dying declaration.
For valid, you see, even if the oral dying, regular dying declaration is not recorded, that would not belie the oral dying declaration.
Not at all, Manoj, not at all. I'm not at all submitting, Manoj, that the oral declaration would mean nothing.
Yes.
My submission is, Manoj, first is that it's not given at the earliest possible opportunity. She travels from home to the hospital and then waits for the sister-in-law to come, and only then she makes the dying declaration, Manoj. That raises a question mark. And Manoj, second is that I'm acquitted so far as the offences under 498A, which is set up by the prosecution as motive for me to do this marriage. And 20 years after marriage, dowry demand, although I'm acquitted in that.
It is not dowry. You are having a second wife. That is the reason.
Let's say, no.
That is worse than dowry.
PW1 who
That
talks
is worse
about,
than dowry.
so far as PW1 is concerned, before whom allegedly the dying declaration is made, she talks about the presence of PW2 also, who happens to be the daughter of the deceased, my lords. And PW2 has turned hostile. If I may just take, my lords, to the evidence of PW2, my lords, who's the daughter, page 36. Page 36, my lords, it's a very short testimony. My lords, para 2 at page 36. My lords have it. Page 36, my lords, para 2. My lord has.
Yes, page 36, yes.
This is the testimony of the daughter who, according to PW1, was there the entire time. My mother, I'm sorry.
Yes, yes.
My mother died due to burn injuries about 1 year back while under treatment at so-and-so. Immediately after the incident, my mother was shifted to so-and-so and later...
He is hostile. He is hostile.
She's turned hostile. And according to one, she was there all the time. And then
mother died, father is alive. The children always respect those who is alive, one who will take care of in future.
But only for that reason, my lords, it could not have been, her testimony cannot be disregarded, my lords. It is not a fact that I have stated before. This is where, my lords, she talks about her contradiction.
She is hostile.
And then, my lords, the last para, which is para 5 at page 37, cross-examination by the defense. Our house comprises of 2 rooms. I've got 4 other brothers and sisters. On the relevant day, I had been to village so-and-so with my father to work at a backlin. On the seat of information,
at least 5 witnesses.
My lords, all 5 witnesses are the family witnesses, my lords. And there was an occasion that
you believe one family, then believe the other family also. If daughter is to be believed, other family members are also.
The independent witnesses were very much.
PW1, PW3, 4, 5,
they are all
7, everybody, all are speaking in chorus against you.
And my lord,
one person may have enmity, but not everybody.
My lord, may just see what are they speaking? All they are speaking is that I need dowry demand.
Dismissed.
Great.
Set your wife on fire and then.
There is delay 645 days.
Yes.
Great for them.
Item 21.
Yes.
I'm seeking for an accommodation. It's just that the arguing counsel is not well. In the morning, I didn't have instructions, so that's what for a parcel.
Here also you sought time.
Yes, we had to file a chart regarding the testimony of the witness.
Earlier also you prayed for time. Why are you not interested?
We'll file it we'll file the chart this week. We'll file the chart this week. The testimonies of the.
Why are you not interested in arguing this?
The arguing counsel is not well that. He's not well today.
Tomorrow?
Tomorrow.
As paid post tomorrow. Yes.
25.
Yes.
Good afternoon, Lordship. I'm appearing on the behalf of petitioners.
Yeah, good afternoon.
Oh, good evening.
Not the language of
So it's after 12.
Yes.
Sorry, Your Lordship. Your Lordship, from the outset of the facts, the apprehension is regarding the recording and the appreciation of the records and the conduct of the investigations by the competent authorities under the NDPS Act. I would like to begin with the fact that just like an opening statement, which I would like to submit, that in the pursuit of proving the culpability of the accused, that it should not be collateral damage because they are not in any way privy to the ill doings of their son. How is that possible? Because in 2015, there was a disownment deed which was registered, and there was no relationship there.
With the financial investigation and the trail is complete.
The
money trade of this ill-gotten money from heroin trade is complete. That is the financial investigation.
Your Lordship, the thing is, the trail is not being able to complete because the prosecution just has one thing against, because there is no documents on the record. The only transaction is about one one transaction which involves rupees 3 lakh rupees, and which is an isolated act, which cannot be held in isolation just to prove that if my relative is accused
Dismiss, not interested.
Lordship, if I can just give one more fact, if you allow me. Your Lordship, the freezing order was given on 17/1/2024.
Yes.
And it was also reappreciated on 13/2/2024. The procedure of, because the seizure memo was also not signed. So there is a grave, there is a, like the seizure was not conducted in a proper way because it was not signed, it was not stamped. And this raises question on how the seizure was conducted and how the...
Yes, next case.
Item 29.
Yes.
Lord, the charge sheet has been filed. I'm not an accused, my lord. The investigation has been completed. I was not even named in the FIR. And Lord, this material fact was...
No, it is entire your operation.
No, not mercy.
It is your operation.
But the investigation is complete, my lord. I'm not an accused. Charge sheet has been filed. Nothing has been found against me, my lords.
It is only freezing. It will be defreezed.
No, not I applied for defreezing.
I never allow these gestures.
No, you should say sorry. Please apologize, sir. Please apologize.
Yes.
So, my lords, we applied for defreezing, my lord. That has been rejected. We went to the High Court. High Court heard the matter. The status report was called. And if your lordships will see at page 246, my lord, of the status report,
yes,
it's clearly mentioned. Just have the page 246.
Your contract is terminated.
Sorry?
Your contract is terminated.
Terminated, that's a different matter, my lords. But so far as...
Which amount you have amassed?
No, my lords,
this has to be freezed.
According, no. So if
you asked, this has to be freezed.
If that was so, my lord, then I would have been made an accused. The charge sheet has been filed. I am not an accused. Cognizance has been taken. I am not an accused.
You should thank them if you're not an accused.
Then my lord, then they
should thank them that they have not included you.
So the freezing...
They should have made you an accused.
The freezing cannot continue, my lord.
Let them come, we'll say them.
Yes.
We'll tell them.
To make me an accused?
Yes.
I don't think you're...
Because if you if according to them, it is your account is to be freezed because the money has come to you.
No. So
then you should be an accused also.
So now, my lord, how much money? Let me tell you. According to the FIR, my lords, this is beside the fact that I am not an accused, nothing has been found. 45 lakhs. My lord, this huge amount, my lord, is about relating to 42 plazas. Toll plazas across the country.
Yes, it's a huge scam.
So, my lord,
parallel software is
across the country.
It's a...
Now, my lords, my amount, if my lord, even if my lord, the FIR allegations were to be accepted, the amount of my lords to my account would have been 45 lakhs. That is page 205, my lord, 45 lakhs. Now, my lord, my 55 accounts, my lords, have been seized, my lord, freezed, and my lords, in which, my lord, there is an amount of 25 crores. I have 900 and odd contracts, my lord, going on with NHAI, and my lords, I'm not able. It's more than a year now, my lords, more than a year, and there is no material against me. There is no material.
The counsel for the petitioner submits that that the petitioner is not an accused in the FIR filed against
and also
the employees of the toll plaza.
And also the charge sheet, which has been filed. Investigation
FIR and the charge sheet. FIR and the charge sheet filed against the employees of the toll plaza. And yet, for last about 1 year, petitioners' bank accounts having deposits worth rupees 25 crore has been freezed. About 25 crore has been freezed. Issue notice.
I'm so grateful.
Item 43.
Yes.
This matter of coming after notice.
Yes.
Coming after notice, my lord. I have a humble submission before this honorable court. Lordship, may kindly admit my SLP and the original report may be called for.
Admit SLP, why?
Matter is coming after notice, my lord.
So after notice, whatever comes, leave has to be granted.
My humble submission is that, my lord. Lordship, may kindly see, even as for the prosecution.
Trap is there, tri-court, high court. Yes.
All recordings exhibits.
No, my lord. As per the prosecution case.
As per the prosecution, the only
have
point is
discharged
that
all-
you are a small telecom mechanic. Therefore, you should be let off.
No, my lord.
That is the only ground that I am a small employee, please.
Three submissions, my lord.
Otherwise, there is nothing.
Three submissions, my lord. May I make three submissions? Number one, my lord.
Yes.
As per the FIR and even as per the prosecution case, I have discharged all my official duty without even asking any bribe. That is page number 8 of the additional only FIR, my lord. I installed the telephone without asking the bribe. That is their own case, my lord. Once I discharged the official duty, my lord, according to them, on that day, namely, my lord, on 15th of June 2005, I asked for bribe. But my lord, in the cross-examination, the PW1 has agreed that there is no evidence. And there is no complaint also from the part of PW1 with regard to the incident which occurred on 15th of June 2005, my lord. Subsequently, my lord, the next stage, according to the prosecution, I have made the demand over the telephone. Even that also, my lord, page number 30, that has been found as an omission that amounts to contradiction. There is no telephonic conversation. Now, my lord, the last stage, third stage, my lord, they telephone me and they have offered me, my lord. That is on record. I never demanded. Kindly see page number 13 and 17 in the additional audio.
Page number
13 and 17, my lord. Additional audio. This is what is the prosecution relying, my lord.
There is no pagination in the additional.
13 and 17, my lord.
Paragraph or page?
Page, my lord.
There is no page.
No, 13, 1-3, my lord. Additional audio, my lord.
No, additional. Sorry.
Additional audio.
There are additional document. There is no additional document.
I filed the additional document, my lord.
When?
My lord, it is filed maybe 2-3 months back, my lord.
No, we have the main paper book and then counter affidavit.
No, additionally, my file.
We have a
copy. And yes, my lord. I never asked any demand, my lord. Even as per their own telephonic.
It is not showing in the record. It is not filed. There may be some defect.
No, it is on.
There may be some defect. Therefore, it is not.
Kindly have.
What is the IA number?
Lordship, I kindly have it after 2-3 weeks, my lord. It is already filed.
The counsel for the petitioner submits that he has filed additional documents on what date? What is the filing date?
Seventeen 10/20/25.
17/1.
17/10.
17/10.
Please, my lord. In the October, I filed.
है क्या?
On record नहीं है इसमें दिखाया था है कि फाइल का था
On record नहीं है तो दिख कहाँ से?
Not available दिखा.
So not available. On 17/10/2025. Full stop. Let the document be placed on record. Post after 4 weeks.
Please.
Yes.
So we have a number 267052 of 2025. It was served to us.
2670?
267052 of 2025. That's what permission and application to.
In IA number so and so. Yes, next.
267053. So obliged.
Item 44.
College. Also, people just state college. I would have issued notice on the limited point that regarding the quantum of the sentence. This is a matter where the deceased was killed via bow and arrow.
Arrow?
Yes, my lord.
How much period he has undergone? 7 years, 7 months. In 2018.
My lord, he is in.
2018, he is in jail.
Yes, my lord.
Almost 8 years now. He is not here. None for the petitioner. Moves the matter after summer vacation, so that he goes some more time. Yes.
Yes, Your Lordship, I have a humble request of the counter affidavit has already is ready, but I am awaiting the affidavit, Your Lordship, in this matter. So kindly give me 1 week.
Counter affidavit is ready, but
Sorry,
affidavit is not ready.
I'm so sorry, Your Lordship.
Yes.
The counter is ready, but the affidavit is awaiting. So Your Lordship will give me 1 week time.
Washing.
Yes, my lord.
Yes, Your Lordship.
Oh, that gym matter.
Yes, my lord.
Yes.
I'm a gym trainer.
What is there? There is nothing in the matter.
Your Lordship, give me 1 week's time. Okay.
Gym, some customers from this gym went to the other gym.
The venture didn't work out, my lords. That's the only issue.
Yes.
Dispute.
The informant's wife and mother-in-law.
Yes.
Same matter, no?
Yes.
They were having this agreement with the accused.
Yes.
Yes, my lord.
The State Council is allowed 2 weeks' time to file counter affidavit. Post the matter. On this 17th, it's 16th. On 17th March.
Much obliged.
Grateful.
Yes.
My lord, some short pass movements.
Passover. Yes.
47.
My lords, I'm appearing to the respondent in this matter. I'm seeking a short accommodation on behalf of the arguing counsel. He is on personal difficulty. He is unwell.
2019 matter, what is there? Civil?
Yes, my lords. It's a tenancy matter.
Common tenancy.
Two courts are in my favor. The appellate court and the high court is in my favor.
You are landlord?
Yes, my lords.
Why are you delaying?
My lords, the arguing counsel is unwell.
As paid by counsel for the respondent. Post the matter after 4 weeks. Yes.
Item 48.
Much obliged.
Yes.
Proceedings are complete, my lord. For finding, I am ready. Subject to my lord.
My lord, I am appearing for the respondent, my lord. University.
Yes. Yes, Mr. Chaco.
Yes, my lord, I am ready. If I see
How much
friend
time
is
it will
actually
take?
ready, my lord, I don't have any problem.
Some time.
Half an hour.
For you.
I got a short note, my lord. This may be sufficient.
This is arising out of some departmental inquiry proceedings.
No
Yes, my
inquiry.
lords.
One commission was appointed. One commission, my lord, fact finding body. It gave a report based on that as a dismissal without any charge.
We'll hear it on some Tuesday.
Yes, my lords.
Huh?
Yes, my lords.
Tomorrow. This
Not to-
Tuesday is tomorrow only.
2 weeks there. Next Tuesday, I'm not there. My lord.
Yes.
1 week thereafter.
Post. What is the urgency?
Let us see.
You are dismissed.
Yes.
Since when? 2020 this is pending.
Yes, my lords.
Post on. We'll take it on 24th March.
We get 2 p.m.
Yes.
2 p.m. We'll take before 2 p.m.
Grateful. Grateful.
Item 49.
I know you lots of speed.
Obliged.
Huh?
I know you lots of speed.
Let us see. We hope that it will be taken. Yes.
Question for a Passover.
Passover.
49 minutes. 49.
49. Yes.
Malas, I am maintaining appearance for Delhi. I've asked for the wakalat. If Malas will permit me, it's a neat question of law. On leave to defend Malas.
What problem?
Serious infection, Malas. Malas can put it next week. There's no difficulty.
Yes.
Yes, no problem.
As prayed, post the matter in the week after next. Yes.
And 2 minutes.
Much obliged.
Item 15.
Yes.
Actually,
Leading person is in code number 12.
we wanted for hearing on some day. If the learned colleague doesn't have an objection, it can be next Tuesday for hearing. Otherwise, it's matter where the question of limitation from the issue of sales certificate should be counted or not. Actually, this question has been referred to 3 honorable judges. But since Radhika is not here, I don't want to say anything. Otherwise, if your lordships can take it up on Tuesday for hearing, next Tuesday if it's not difficult.
So it is ripe otherwise?
Otherwise, it's ripe. Only thing is, one of my contention is referred to larger bunch, but Radhika may oppose it. So lordship, I put it for Tuesday for hearing. I have no difficulty.
You may have it on a fixed date.
Yeah, sorry. Thank you. Sir.
10th March?
10th March. Grateful.
Tuesday, yes.
Obliged to lordship.
Yes.
Item 51.
May I please, Lordship? Minister, I am appealing for petition in this matter. Service matter, Malas. The benefit of service has not been extended to the petitioners, my respective submission. There are 4 heads, out of which 1 head has been given, Malas. Remaining 3 has not been given. There are 4 heads.
4 grades.
4 heads of how the money has to be given to this man. I just prepare a short list of this for your Lordship.
Yes. No, this is arising out of some contempt proceeding.
Yes, arising of a contempt proceeding. This is one set.
So everything has been done.
No, just
except 1 grade, which you say 1 grade is not granted.
No. 4 heads. Let's Lordship, I'll count.
4 heads.
4 heads. Suppose.
What are those heads?
Heads that I have explained. Just given a Lordship, there is a calculation sheet I have given. There are 2. One is list of days, one is calculation sheet. What has not been given? Here, salary not paid from 11/4/2018 to 15.
The first one or the second one?
It's a thin one, Malas. It's only 2 pages.
Thin one.
I've given the calculation how he has been deprived, Malas. He's a head of the department, so working in the capacity of head of the department in Sanskrit University, Malas.
You see,
even when his subsistence allowance.
When I used to be a lawyer, some judge used to say that when you have to prepare such a lengthy synopsis in a contempt matter, that means there is no contempt.
There is a because Lordship,
contempt has to be writ large.
Therefore, I made it short one.
If you have to make out an argument for 1 hour for contempt, then there is no contempt.
Therefore, I made the short one to understand.
The press cause of action.
Yes.
Yes.
Lordship, can you see? Number 1 is the salary not paid. Lordship, got the thin one.
First, see the direction.
Lordship, can you count to page 149? While his order of termination has been set aside.
No, what was to be paid in view of that?
129. Page 129 is the direction.
120 or 40?
129.
149.
149. Sorry, 149. Sorry, Malas. 149, Malas. Start at page, Malas. 129. 49 is the direction. 149 is the direction. May I read, Malas?
Yes. Petitioner, however, shall be reinstated into service forthwith and be extended the benefits which he is entitled to.
He is entitled to consider to his reinstatement into service.
What benefits you are entitled to? According to you?
Yes. This sheet, Lordship may take up this sheet now. And will show from the documents itself. Their own calculation.
Salary not paid.
Yes.
Now,
salary not
salary
paid
is paid.
From 11/4/2018 to 15/3/2019, Malas.
Now it is paid.
It is paid now. This head, I have no claim, Malas.
Yes.
Next is my subsistence allowance, which cannot be stopped. Lordship are aware that there is a series of judgment of this case. It's from September 17 to 10th of April 2018. This total amount is, Malas, 9,24,160. It has not been paid.
Not paid.
Not paid. Now, Lordship, kindly come to page next, Malas. That is the areas of salary payable as per the recommendation of 7th Pay Commission, Malas. Everybody got it, Malas. It's 1/1/2016 to 31st/12/2020.
admitted amount is 54,96,204. Their own calculation, malas. The controller of finance has calculated this. It is on record, malas. I placed it on record.
Years of salary 1,116 to 31,12,20.
20, yes.
It is 54 lakhs.
54 lakhs because 7 pay commission revision was so much. Malas, he is entitled for this.
What was you doing? That you are a professor?
I am a head of the department, malas.
Head of the department.
Head of the department, malas. In the Sanskrit University, malas. Next malas medical. Now, this October, 3rd October, they have paid the medical. This 30,000. Paid. Lakshmi I don't pay. Now, 1 month salary which was not paid for the month of May 2022, 1,65,000 is my salary, is not being paid. My total claim is malas 81,56,103. Amount received is malas 15,40,204.
Yes, what is your stand?
And all these documents are on record, their own calculation, malas.
What is your stand?
But I am for state and they are for university, my lord. As far as state is concerned, there regarding the
Who will pay? State
university will pay, but university will pay on our instructions, my lord. 7, as far as the biggest amount, 7 pay commission. Regarding that, kindly see my counter affidavit at page 28. There is a GOV. This amount was not given to anyone. He is not discriminated. This GO started from page 24, 4/12/2020, and relevant is at page 28.
And why High Court dismissed the contempt?
High Court satisfied.
No. High Court.
Just a minute. One para.
Why High Court? Malas High Court gave a check of rupees 15,04,000 before the High Court, saying, my lord, we are paying him. The High Court misunderstood the remaining amount has not been paid. Lordship, can you see what my learned pen is saying is Lordship, can you come to page 148. Their own documents, it's not my documents, malas.
Page 28 of my counter. Just a minute, Lordship.
148 of the paper book, malas. Lordship, will have a look at it.
My counter. Yes.
Let them.
Sorry.
I'm asking question to them.
Sorry.
Page 28, para 15 of that GO dated 4/12/20. The benefit of revised pay scale will be admissible notional from 1st January 16 and actual from the date of issue of government order. This is of 4/12/20. Areas between 1st January 26 and date of issue of government order will not be paid. This is applicable to all. If we have not given to university, how university will give it to him? And he is asking this thing which was not paid to anyone. He is asking these areas.
Which page you are reading?
Page 28, para 15, my lord. This is the GO which started from page 24. Regarding sanctioning, revising the pay.
24 of the counter.
In my counter, my lord. Counter by state. Yes. No, not state, but respond number 3 and 5. Basically, they are state authorities.
Which part you are reading?
It starts from 24, page 28, para 15. The benefit of revised pay scale will be admissible notional from 1st January 2016 and actual from date of issuance of this of government order. Areas between 1st January 2016 and the date of issue of government order will not be paid. Without any discrimination, this was applicable to all. And Malad, it's settled position in view of our financial condition. We decide this.
This logically come to page 240. Their own calculation, Malas. I have not done it.
This is the bulk part of 54 lakh which he is claiming.
248, then I'm coming to their own documents, Malas. It has been given to each and everybody. Logically come to page first.
You may be right, but can be made part of the content.
First, logically come, logically have page 248. I'm showing to your lordship. And then I'm coming to their own documents. This is also all their own documents.
I don't know what is.
Malab lordship, this is a chart given by who is given it? Malab the Lok Suchana Adhikari Uttarakhand Sanskrit Vishwavidyalaya and Malab.
What is the 248 chart?
Malab
248 chart. What is
248 is charts, but after the order of the High Court, my entire dues were calculated by the finance, Malas, controller
No,
of
it is
finance.
calculated for the fiscal purposes. So that your scale is determined.
Malas, no, not
Your
scale.
your actual entitlement as on the issuance of this circular is calculated.
As per this,
So as proof that this has been paid to any employee.
Yes, it is. I have proof. Malas.
Who was that paid?
I'm coming to that. Why
you come to that? Don't.
Yes, when you
Come.
Page 51, Malas.
Page 51 now?
Page 51 of my rejoinder affidavit.
They are not very rejoinder.
But there, see, this is head of the department, is a teacher. Because subsistence allowance not paid. Is it the law?
Yes, what about subsistence?
No,
Sir, for subsistence, she will answer, my lord. For subsistence part, they will
Just take 2 dates.
Malas, when you finish this one, I'll come into the subsistence allowance later.
Yes, first one by one.
Yes,
Yes,
one by
surely.
Rejoinder which page?
Page 51.
Surely.
Page 51.
We'll serve back.
But 3% is attacking at the same time.
You are attacking 3 or they are defending.
3%, including Gagara.
They are defending.
I'll answer all this.
Yes, page?
Page 51, Malas. Rejoinder affidavit, annexure RA5, Malas. 16/10/2051 of my rejoinder, Lordship, what? It was filed on 26th of July 2024.
Which page? 51.
26th of July 2024.
Yes.
Rejoinder, page 51, Malas.
Some office order is.
Yes, office order. Issued by the university under the instruction of the government. Malas, made it. The government of Uttarakhand Sanskrit in education section government order such and such dated 4/11/2000 by amended the honorable vice chancellor, teachers and equivalent cadre have been notified to immediate effect of 7th pay commission with certain conditions. Is 16/12/2020, Malas.
Payment of proof of payment.
Proof of payment, Malas. I have not paid till date.
No, for others.
For others. Lordship, let them by your affidavit, let them say
there is no proof of not payment. Only when payment is there, there will be some proof. You demonstrate us that after this order.
Yes, Malas.
Of this 4/12/2020.
4/12/2049, yes, page 1.
And thereafter, at page 33.
Any amount has been paid to any employee from 16 to 20.
Take it from me, Malas. Each and every employee have been paid. And therefore they have calculated. Malas, therefore they have calculated.
From you.
Malas, Lordship,
you can take only by way of some order.
Because Malas.
Yes, come to suspension. Suspension. You have no case on that area.
Lordship, kindly come to page 248 once again, Malas. Lordship, kindly see. Why, what I am trying to show is, Malas, here the controller of
finance.
Controller of finance.
Come to subsistence allowed, otherwise you will lose everything.
Malas, Lordship, kindly. Yes.
Subsistence allowance, yes, what is
yes, I'll just address on subsistence. As far as salary for 1 month is concerned, Millers,
yes.
I believe, Millers, Lordship will direct us to pay that.
Yes.
I think that's not correct. Lordship will direct us this serial number 5.
Yes.
This salary we will have to pay, Millers. Now subsistence, Millers, he was suspended in September of 2017 and 30th of August 2017, Millers. He was suspended. He was asked, yes, 30th of August 2017. And by an order, he was asked to report to Central Library every day. Millers, an employee is suspended. He's asked to report to a particular place every day and mark attendance. He never came for 8 months during the period September 17 to April.
That is who will go. You see, during suspension,
yes,
who will go every day and mark attendance? There are judgments to this effect.
Millers,
you don't expect a person who is in suspension
yes.
to come to office at 10:30, mark his attendance and then go back.
Because it's not to the office, to the Central Library.
You have to pay that. Take.
Malas, and one more.
Take.
Malas, one more.
We'll dispose it off.
Yes, please do, Malas.
Malas,
give us some time. Lordships have made up. Lordships have
7th pay commission, Malas. Malas, then Malas, I can place on record some documents which showing the other employees are paying. This is the queries, Lordship, calling for your.
No.
Malas,
you come again by filing MA if you find any service.
Because the High Court has left it open.
Find any proof?
Lordship, give the record, can't file it. Lordship, now they can pay this whatever not pay. Two heads I got it, Malas.
Less.
15 lakhs, 4,000 I got.
This SLP arises out of.
Sorry, this SLP arises out of order passed by the High Court, whereby petitioner's contempt petition has been closed on finding that the order passed by the High Court on 20th December 2018 in writ petition SB number 155 of 2018 has been complied with. Yes. Full stop. Para. It is contended by learned counsel for the petitioner that the petitioner admissible amounts have not been paid to the petitioner on 5 heads. That is, number 1, salary; number 2, subsistence allowance; number 3, arrears of salary as per recommendation of 7th Pay Commission; number 4, medical bill; and number 5,
1 month salary.
1 month salary for May 2022. But learned counsel for the petitioner would fairly submit that head number 1
and 4 has
already been paid. Therefore, the non-compliance is now confined to payment of subsistence allowance, arrears of 7th Pay Commission, and 1 month salary. Full stop. Para. Sri Gaurav Agrawal, learned senior counsel, would submit. Senior counsel appearing for the
university.
Respondent university would submit that. Should we record your statement about 1 month salary or
consider it that my learned friend gets into trouble. So I won't never get into trouble.
Gaurav Agrawal, learned senior counsel appearing for the
Respondent
university, and Mr.
Abhishek Atre.
Mr.
Dr. Abhishek
Atre.
Dr. Abhishek Atre.
Dr. Abhishek Atre, learned counsel appearing for the state of Uttarakhand, would submit that would draw attention of this court to the order dated, what is that, 20th December 2020, to contend that the arrears of 7th pay scale has not been paid to any of the employee of the state government
university
and the actual payment of the pay scale, 7th pay scale, has been granted with effect from the issuance of said GO on 4/12/2020. Therefore, petitioner is also not entitled for arrears of salary of 7th pay scale.
Correct.
Full stop. Insofar as the non-payment of subsistence allowance and 1 month salary is concerned, learned counsel for the respective respondents would submit that whatever amount for would submit that the petitioner shall be paid the amount, if found eligible by this court.
Correct. Very good.
Don't say if they can.
Yes, the submission
again.
Piyush, it's our submission. Lordships are recording to save me.
नीचे वाला हाथ तो लगाया नहीं.
Don't worry. If Lordship once says it has to be paid, it has to be paid. Below. That's all there is.
Following you must listen to. Have faith in court.
Yes. Once your Lordships have said it, said it. End of the story, Willows.
Upon hearing learned counsel for the parties at length, we are of the considered view that petitioner is entitled for subsistence allowance during the period when he was placed under suspension pending inquiry, pending domestic inquiry.
Yes.
Which has been held, which has been set aside by the High Court, and the petitioner has been reinstated with all consequential benefits.
Correct. Lordships are right.
Full stop. Similarly, the salary for the month of May 2022. Similarly, petitioner is also entitled for the salary of May 2022.
Millers.
Full stop. Accordingly, the appeal is allowed. Appeal is allowed in part, and allowed in part. However, instead of holding the respondents guilty for committing contempt, we direct the respondents to make payment of subsistence allowance to the petitioner for the period during which he was placed under suspension, as also the salary for the month of May 2022.
Allow me to invest.
Full stop. Para. Let the above payments be made within 60 days from today.
Yes, yes, we'll do that.
Yes.
Grateful to your lordship.
And my lordship, that part only, if my lordship record my submission saying that I may be permitted to file an AMA. So for that, if I can show the other stuffs are getting it. According to my client.
You file it.
No, please, my lordship.
We'll entertain it. Gentleman problem. Before my retirement, you file, I will entertain.
It's fallen for your lordship. Lordship should give.
If before my retirement, you
say so. It has fallen for your lordship. Lordship, kindly record. One line will. Lordship, please record.
See, I'm making a promise. It is on record. Video you can take. Video you can take. Yes.
Very, very grateful.
The other day, some lady was granted 1 crore of maintenance as final settlement by Honorable Justice Gawai, then CJI. And she was saying that Justice Gawai had promised me that this amount for full and final settlement will be increased later on. And she was requesting your lordship to see the video that day.
I also could do that.
Very obliged, your lordship.
Yes.
Lordship may kindly list it on some other day. The arguing counsel is not there.
What is this? Again, contempt.
Yeah, please, my lords. I'm appearing for the petitioner, my lords.
Yes.
In fact, my lords, 1,11,800 has to be paid yet, my lords.
All the payments
And this we had already put in on affidavit in 2024 itself.
You are for the petitioner?
Yes, my lords, I am for the petitioner.
So what remains to be complied with? Now, let's
My lords,
all the amount has been paid.
all the amount is paid.
Nothing
No, my
remains.
lords, no. 1,11,800 has to be paid. We have already filed our objections to the application for condonation of delay, which they had filed, in which at page 10 we have specifically mentioned, my lords, that this amount has to be paid. The affidavit was filed quite long back.
Go through it.
I have a chart of the.
That amount is still remaining.
No, all the amount, all the dues are clear.
No, my lords, it's not been done. Last time also when he had come, he said that he will talk to the council, standing council, advocate on record and get back to me, but we have not yet received anything, my lords. We have also given the chart.
Consult her and just understand.
Okay. I'll do it.
What is that head for? What is that amount which is not paid?
1,11,800.
For what?
For areas of rent.
Areas of rent.
Yes, my lords.
Oh, yes, it is that matter. So areas of rent, there should be no difficulty in understanding.
I'll share the chart with you. I've shared the paper.
As to what is that particular month for which arrears is remaining.
I'll share it.
It is so simple.
I'll share it.
In fact, there is a direction by us.
Yes,
on page 12, that let the learned counsel for the parties settle the calculation and inform this court about the present status regarding compliance of order.
I have the payment sheet with me.
No, about calculation.
Is the calculation? I have the calculation.
According to the petitioner, what is the amount which is not paid?
1,11,800.
Now we have recorded that.
I have the calculation sheet with me. If you want to look at it.
Last time only it has been recorded, my lords. And my lord, we had put it
But
in
they have the calculation sheet.
I will share it with her. It may be listed some other.
Pursuant to our order dated 5/12/2025, learned counsel for the respondent would place on record, would place before us a calculation demonstrating payment of entire amount due to the petitioner. Full stop. Let the respondent place the calculation on record.
My lords, we have already filed the calculations, my lords. It's already there in the.
It's already there?
Yes, my lords. It's already there, my lords.
No, calculation satisfying that there is no dues as per your calculation.
No, that one not on the board. I'll paste it on the board.
My lords, there cannot be anything like that, my lords.
Let the petitioner file calculation showing that no amount is due to the petitioner.
My lords, he responded, my lords.
To this?
You have said let the petitioner file.
Let the respondent file.
The respondent, yes.
That no amount is due to the petitioner. Yes, you file that calculation which belies her statement.
My lords, in fact, in October 2024 itself, my lords, we had filed an affidavit showing that 1,11,800 amount
We will dismiss this contempt on the next date if we are satisfied that amount is paid.
Okay.
Otherwise, you will say 1,11,000, then next we.
No, my lords, we have given the
Next
calculations.
installment, you will say 55,000 is remaining.
My lords, we have put the calculations also, my lords. It's not
Yes, next.
we are talking in air.
53.
I have got one request, but this involves some issue which needs to be decided. But would my lords consider of keeping it for a non-miscellaneous day? One thing. In the meanwhile, Lord, I have some suggestion to my learned friend about Lord, what way it can be sorted out through negotiations. Lord, my instructing advocate has got some instructions about it. I will talk to my learned friend. Your Lordship will fix it for some non-miscellaneous day. In the meanwhile, we will give it a try. It's about Lord, the closure of the establishment and consequential retrenchment of about a few hundred employees.
We've had many rounds of discussion, many offers made. Unfortunately, they spawned all the offers, and time has now gone by and working against them. We don't mind when my learned friend Mr. Navre says that he wants to try and find some solution. I'm always happy to sit with him. But in the meantime, I join him that let it be kept tentatively on some non-miscellaneous day. In the meantime, we'll sit together. And if we can arrive at some solution, well and good.
What should I say? Simply adjourn or should record that both the parties will meet? What?
It may be simply kept on some data. My learned friend and I
for some non-miscellaneous day. In the meanwhile, we'll try to give it a try.
Let it be as an order of the court.
Very well. Very well.
Post the matter on 7th April. Tuesday.
Yes.
In the meanwhile, parties may utilize the time to explore the possibility of settlement.
Yes. That will help us a lot. In fact,
yes, that is what. Some observation.
Your Lordship, kindly come to the last order while issuing notice, Your Lordship. That issue summarized by Your Lordship while issuing notice. Second, Your Lordship. The issue is that, Your Lordship, I was appointed as Anganwadi
worker.
Yes, Your Lordship. Worker, Your Lordship.
And now you are removed.
Yes, Your Lordship.
Why?
Because there were two qualifications to that. One, she should be the domicile, local resident of the Anganwadi area.
That is everywhere. In every state.
Yes. I am, Your Lordship. Second one is 10th standard pass. SSLC in Karnataka, the SSLC. So I was appointed. The others, respond number 5, challenged that before the High Court, single judge dismissed her, and division bench of the Honorable High Court set aside that one, my appointment, Your Lordship.
On what ground? You are not 10th pass.
No, I passed, Your Lordship.
what is
Their
that?
contention is that one. I passed pre-university college +2.
That qualification.
Yes, for the post. The basic qualification is the domicile. Second is a 10th pass. She has the.
What is now High Court has done? The
No, she has the.
he has been appointed.
No, yes, Your Lordship.
Yes.
+2 is the desirable one in case the local domicile candidate is not available to that post. So,
yes.
So my argument, Your Lordship, so before you even single judge and all, I possess both qualification. One is I am the local domicile, and second is 10th pass. That village, Your Lordship, comprises 3.
What is her qualification?
She is not the resident of the particular area, and she has +2, 10 +2.
No, your qualification is intermediate pass.
No, 10th pass, SLC. That is a required qualification for anybody. Even the failure candidate also can be appointed if she is the resident of a particular area.
Respond number 5. C is respond number 5.
Yes, Your Lordship.
C is intermediate pass.
Yes, +2, Your Lordship.
PUC.
Pre-university
Pre-university college. It is +2, Your Lordship.
Called as pre-university. +2, Your Lordship.
It is intermediate also.
Yes, Your Lordship. +2.
That means 12th.
Yes, 12th. That is the desirable qualification in case if any, she can get 2 more marks. In case if she is the resident of a particular area.
Opponent is not a resident of local area.
Yes, Your,
That is factually incorrect. I am
this is
contesting
what the
that.
state also supports, Your Lordship, in their counter in paragraph 3. State also supports that, Your Lordship. Kindly come to paragraph 3, where the state also affirm my candidature for that post, saying that one +2 is only desirable.
Who is working now?
I am working, Your Lordship.
She is.
I am working, Your Lordship.
After the High Court order?
Yes, Your Lordship.
So there is no interim order in this?
No,
Your Lordship.
Then
no, she can be also replaced because I was working
any
right from
possibility
2011.
that both can be accommodated?
That state, that's what I was proposing, Your Lordships. There are multiple positions of this nature.
Anganwadi worker, think of.
They can accommodate her somewhere.
Instructions in my lords.
You see, because according to your counter, if C is not a candidate belonging to that local area, then respondent number 5 will be ousted.
That is correct.
Because a candidate who is ineligible
Yes.
cannot challenge the appointment of a eligible candidate.
Yes. So there.
So now you have to find out, you have to request them.
Yes. Second part, Your Lordships.
Nearby locality.
Whatever my lords direct, I can seek instructions.
We can direct.
There are many positions.
Direct, provided you show us that vacancy exists.
I will have to seek instructions, my lord. My lord will list it next week. In the meantime, I'll get instructions and report back to you.
Yes.
Also, one part.
On what particular ground your appointment has been set
Your
aside?
Lordship, she has
How do you not see?
yes, Your Lordship. Mine is that one I fulfill.
Why you have been ousted from employment?
She has +2 qualification than me. She has the higher qualification. That one is only desirable.
One submission. Because I had +2, I get 2 percentage marks addition to that candidate. So I am getting more points than the petitioner candidate. And this issue of residence, Your Lordships, was not contested before the single judge and the division bench. State has never said that I was not part of that locality. My application says has the Tahsildar's certificate of the residence. That is part of the record. And this position for the first time, state is disowning me here.
Your Lordship,
on the issue of residence. Otherwise, I am more qualified than the petitioner because of that bonus point.
Plus
You worked from 2010.
2011.
2011.
2011. Impugn order posture.
23.
2023.
Yes, sir.
I have.
Yes, I worked.
From 23, I have.
The petitioner and the respondent number 5 are competing for the post of Anganwadi worker of area.
Sindhi Hatti village. I will write down, yes, sir.
Sindhi Hatti village.
Yes, sir.
Which taluk and district?
Yes, we will.
So you mentioned.
Yes, yes, sir.
Full stop. The petitioner worked in the said post from 2011 to 2023
till the impugn order is passed.
Till the impugn order was passed by the division bench of the High Court. And thereafter, the respondent number 5 is working on the post. Full stop. Para. There is contest as to the eligibility of the candidate, and both the parties are alleging against each other that the other party is not eligible. Full stop. Para. Let learned state council seek instructions as to the post of Anganwadi worker in the same or nearby taluk.
There are three. Still, there are three in the same village. There are three Anganwadi centers around.
Particularly for the reason that, according to petitioner, 3 posts of Anganwadi workers in the subject.
Your Lordship, not post.
Three Anganwadi centers.
Center in the large village, 3 centers.
Every center has 1 post. That 3 vacancies, that 3 Anganwadi centers are presently not occupied by regular incumbent.
Your Lordship, that's not you. I'm saying that in that village, the 3 centers are there. They can find out if
there is any vacancy, they can accommodate her.
We are not submitting the vacancy. Centers are in the same village.
क्या लिखिए उनका statement? Let London State Council लिखा है ना वहाँ है ना?
Let London State Council seek decision as to the vacancy, the post of Anganwadi in the same
vacancy,
particularly for the reason.
Vacancy in the Anganwadi center
Near.
in the subject village or nearby village.
Yes, Your Lord. Yes. There are nearby also. In the same village, 3 centers are present.
Gratefully.
Yes, Your Lord.
Please, my lords. My lords, I'm requesting for an adjournment. The arguing counsel is not well today. 55.
Yes, paid post up to 4 weeks.
Item 56.
56, yes.
Please, my lord.
Miss, huh?
Please, my lord.
Yes.
My lords, there are 3 other connected matters to this. The petitioner are the employees who challenging the forfeiture of gratuity, purportedly under Section 46A of the Payment of Gratuity Act. My lord, which has the forfeiture of gratuity, the order has been passed without any computation of loss. Further, my lord, despite this 4 petitioner having separate service condition,
gratuity were held not entitled. Why?
My lord, in trial court has granted the gratuity to the employees because
High Court and page 23. Sorry, para 23 High Court says not entitled.
My lord, High Court's finding is based on the appellate court's finding, where the computation of loss has not.
Dishonest act.
My lord, kindly see page number 24, in which I have quoted provision of the Gratuity Act, section 46, subsection 1. May I read, my lord?
So gratuity has been forfeited.
Yes, my lord.
Because of your conduct.
Yes, my lord.
Your conduct.
My conduct, my lord.
He is the employee, no?
Yes, my lord. So, my lord,
what is that conduct?
My lord, the allegations are the wives of the employees.
Page 9, para 12. Your Lordship may see page 9, para 12.
Opened a company and delivered certain goods to the employer, and this is the conduct, my lord. But my lord, before that,
Statement, we do not know what.
No, we were not going.
2025, 3 months time was given.
Senior counsel appearing for respondent number 1 to 5.
1 to 4.
1 to 4 submits that the order passed by this court shall be complied with.
Well, we want only one clarification, because one recruitment process started on 17/1/2024. It was completed and appointments made on 22/8/2024. If we have to comply by giving appointment in that one, we'll have to assess their merits of these petitioners. If we find somebody is higher in merit than the last of the appointed person, we'll issue notice to the appointed person, terminate, create a vacancy and appoint. Other option is for us is a fresh process has been started on. Sorry.
Subject to availability of vacancy.
My lord.
That is what you are saying.
No, my lord. What I am saying, we can consider on merit in the first process.
Just listen. Mr. So-and-so, learned counsel, appears for respondent number 1 to 4.
1 to 4.
No one appears for respondent number.
My lords, I appear for 5 and 6, my lords. I'm through VC, 5 and 6.
For respondent number 5 and 6.
Please.
Let counter affidavit be filed within 2 weeks.
My lord. And my lord, 1 and 2 has been transferred out in the meantime from the BTC. The new incumbents have come. Possibly they will have to be.
Because at the time of the order, when it had to be complied, they were in force. So therefore, that may not be relevant.
You give the name of new officer.
We'll give the name and they will be impleted because so that order can be complied.
It is informed that respondent number 1 and 2
had been transferred out.
Have been transferred from which place?
From the respective post under the BTC, and they are now under the government.
Bodoland Territorial Council, BTC.
Transferred out of
BTC.
Bodoland
Territorial Council.
Territorial Council, bracket BDC.
BTC.
TC, sorry. BTC. Bracket post. Let name of the incumbent officers be provided.
Can I just say one thing? Plus, the order had to be complied on 3rd September 2025. At that time, they were serving.
But the order was not even served on us. No notice of the writ petition was given to us.
Not in the council.
As on today.
So as on today, somebody
order has to be issued by.
We'll add them also very well.
And that's what we the officer who are presently occupying.
So when you're trying to be fair with the court, these trying to make it more complicated.
Provide their name.
We'll provide it today itself.
It's kind of short date.
On the names being provided, petitioners are implead the new incumbents in place of respondent number 1 and 2. Who have joined in place of respondent number 1 and 2. Who have joined BTC in place of respondent number 1 and 2.
We'll file an affidavit in 2 weeks and maybe posted in the 3rd week.
We are issuing notice. Full stop. On such on furnishing fresh memo of parties by the petitioner, notice be issued to the newly added respondents.
Okay.
1 and 2 are not.
They don't want to delete
They are
it.
not deleted.
They're
So grateful for that. That's why I wanted.
Yes. Next.
That's a law of contempt.
He is helping you.
I'm so grateful.
Seek employment.
Well, we are trying to help, my lord.
Yes.
You can cooperate. And if it today also says which of the 2 processes you want to consider, we can do it, start it right now.
Don't be under apprehension.
No, we are also
always that he will give you appointment letter. Don't worry.
Very well.
But if you can spell out which of the 2 processes today itself, we are going to consider from tomorrow itself.
We'll discuss it.
Yeah.
So first one or the second one, it's their option.
Just for 2-3 minutes, and he will be able to convince.
Very well.
you.
We'll do that.
Yes.
Can a date be returned?
Because he will have to talk to his client. No?
Hello. We are trying to cooperate with you already.
Yes.
And this is the first time we came to know about the order after receiving contempt notice. Writ petition, we did not receive notice before the
I also think probably now that instead of allowing those writ petitions by accepting the transfer petition, I should not have done that.
No, it's not that.
Frankly speaking.
Well, we are very happy with your lordship's order. We are ready to comply. Only think how to do it. Whether to take the first part or the second part.
It is the same.
Petitions were pending in this High Court. You filed transfer petitions. So we thought while to
and very technically
encourage multiplicity, then you bring again to the High Court. Instead, we allowed the transfer petition and granted the relief which you were seeking in the writ petition in the SLP itself under 142.
And very technically speaking,
not have been done
raised objections also.
Would
And
not
we
have been done by us, but since now.
We are grateful for that, my lord. And
yes.
Next. Will not trouble my lords. But any returnable date
next.
would be given.
But once order is passed, it is our order.
We're ready to comply. That's the first statement I made before the order to go.
Yes.
And can you be after 19th of March, Monday, any day?
Yes. Post on 23rd March.
Hello.
Very well.
We'll file an affidavit. They can give a reply in between.
Yes.
Grateful, my lords. Deeply grateful.
Item 61. Your Worship, requesting for a passover in this matter, Your Worship.
Well, this will take
Your Worship,
some time. I am for the petitioner. Well, I am for the petitioner. This may take some time because we'll have to go to the history of the
requesting for a
industrial
passover, Your
dispute.
Worship.
You are for respondent.
Yes, Your Worship.
He is seeking an adjournment, it seems.
No,
It will take some time. 2018 matter.
Yes, Your Worship.
Yeah, what is the matter? Service matter.
But this is whether the Industrial Disputes Act will apply to the respondent organization or will it be the UP Industrial Disputes Act. and we'll have to go into see which one is prevailing now, the section 25N or 25F. Although I claim that there is a judgment of your lordship in Jabbar Singh's case, which confirms my view that it is 25N, but High Court has held against me. So I'll have to convince your lordship that A, the 25N will apply, and as to why it will apply. So I'll have to go and trace the history of the ID Act and the UPID Act and Article 254 as to how they have.
And counsel for the petitioner posed the matter on 12th May.
My lord, can I file my written arguments and compilation
Yes,
both?
parties may file their written submission along with list of dates.
And compilation, my lord.
List of dates and synopsis 1 week before the next date of listing. Yes.
My lord, may I file the compilation also of judgments?
What compilation?
Well, there are some judgments which your lordship may have to refer to, so I thought I'll put it on record. Then you're
along with the written compilation.
Yes, obliged.
Item 62.
Unique detective.
Your lordship,
What are you
senior
detecting?
counsel is
Yes.
arguing online.
Huh?
Senior counsel is arguing online.
Senior counsel.
Yeah, my lord, there are 15 matters, batch matters in this. Now, there is an issue of whether civil court has got the jurisdiction to determine the case where it is arising under the Industrial Disputes Act. Now, that issue, my lord, under the civil court has entertained the interim order. Against that, my lord, they went to the High Court in MFA. Now, my lord, we are before the Supreme Court in special petition. Now, in this case, what has happened is, my lord, there was the dispute between the employees and they say that boss is the principal employer. Now, that issue, my lord, was considered by the division bench and held that the boss is the boss of the employees.
No, where is the bar?
No,
Well,
yes.
I am appearing for the
62.66.
There is batch.
Yes, my lord, is a batch.
The batch.
62.6.
You are for the petitioner. And Mr. Mahale is also for petitioner.
Yes, my lord. There are two petitioners,
And who
two
is for the
companies
employees?
here.
कितने सारे cases?
The 15 matters are there, my lord.
17 matters.
In that, one matter where Mr. Kasturi is appearing, my lord, he is appearing for the boss. I am appearing for the contractor unique. So, Mr. Kasturi wants to make some.
What is the present
submission.
status? What is about the employees?
Now, what has happened?
my submission
They
is
are working or they are not working?
their appeals have been regular appeals have been filed under 96.
Presently, they
Therefore,
are working.
you may be permitted to take all these grounds in the appeals. We have filed impleading application in the appeals. Therefore, matter can be disposed of, allowing us to make all the submissions in the regular first appeals.
So first appeal is pending.
Yes, my lord, they have filed appeals. Decree has been passed. Unique has passed, filed appeals, and we have filed application for impleading.
So then what is this order?
This order, my lord, granting injunction, which was refused by the civil court. The High Court grants an injunction against transfer. And this, your lordships have ordered notice. And he has reported also in 62.7.
What happened to the original proceedings in the suit?
Suit is decreed.
Suit is decreed.
Yes. Now they have filed appeal under the section 96. And we have filed applications for impleading. Your lordships may allow us to take all these
Impleading
contentions.
means, who are you? Who are you seeking impleading?
I am the principal employer.
Principal employer means?
Bosch, your lordship.
Bosch.
For Bosch company.
BOSCH.
BOSCH, yeah.
And you are detective agency?
Yes.
Yes, madam, we are for the detective.
Security providing
Yes.
or detective you are providing?
Security.
I am providing the security
Detective
guards,
service
madam.
or security service? What?
It is a
Security services.
Now all of them have reported back to the factory where they were working.
What was the suit
Appeals are
about?
filed. Then I think, my lord, your lordship may permit us to raise all these questions of jurisdiction, etc. in the appeals.
ये virtual बड़ा दिक्कत है.
They are all in employment.
What is the suit about?
Suit for not to transfer, to stay the order of transfers issued by the contractor.
And now they have joined at the transfer place. So that is infructuous now.
One person has joined, others have come back. Others have not joined. For 4 years, they said we will not join.
In a suit for injunction preferred by the respondent employees, prayer for temporary injunction was refused by the trial court, against which the petitioners, against which the respondent employees approached the High Court. Am I correct factually?
Yes, my lord. High Court in MFA, miscellaneous first appeal.
Under 43 Rule 1.
Against which the respondent employees approached the
High Court by preferring miscellaneous first appeal, which has been allowed. Miscellaneous
temporary injunctions have been granted.
And during pendency of the said appeals, an interim order has been granted by the High Court restraining the petitioners from enforcing the transfer orders issued against the plaintiff employees. It is common ground that during pendency of this SLP, the suit itself has been decreed.
Yes,
the suit itself has been decreed in favor of respondent plaintiff, and the regular first appeal preferred by the petitioner defendant, petitioners herein who were defendants in the suit, comma.
I was not a defendant, Mullah. Sorry, Mullah.
Plaintiff.
I was not implicated at all. I was
Who are? You are seeking impleadment in the High Court or here?
No, no, madam. I am the defendant, and I have filed the appeal.
Just keep
That is
quiet. You are the defendant.
I am the defendant, contractor.
I am the impleading applicant.
And he is in the impleading applicant.
No, we are
because
not.
They did not implead me in the suit.
We are not. There is no dispute about who is who is. We are just narrating the facts as to what has transpired in the.
Very well, very well.
Yes, ma'am.
Yes. Please.
and the regular first appeal preferred by the petitioner herein, who were defended in the suit.
Defendant in the suit is pending consideration before the High Court.
And your lordship may please say Bosch was not implemented at all in the suit.
Considering that the present proceedings had arisen at the interim stage,
yes, Lord.
And thereafter suit itself has been concluded. The subject matter of the SLPs have been rendered infructuous. Full stop. Para. Accordingly, all the SLPs are dismissed or disposed of as infructuous, keeping open the leaving open for the parties to raise all the grounds, both legal and factual, in the pending appeals before the High Court.
Including jurisdiction, Lord.
Jurisdiction, my lord.
Full stop. Including the issue of jurisdiction. Full stop. The impleadment sought by principal employer, BOSCH capital में रहेगा. Bosch shall also be considered on its own merits. Yes.
My lord, one more aspect, my lord. This order will apply only to 62.1,
No, it will. We have
62.4,
dismissed all because all have become infructuous.
because
This is
appeals
against
are not
interim
made.
order.
Very well, my lord.
This is against interim order.
All pending appeals.
In fact, there should be only one line order.
My lords,
This
my lords,
product
I'm really
of
grateful.
2-3 pages, one
We
line
are
order.
really grateful, my lords.
Dismissed as infructuous.
It could be well done, but my lord, it will create problems.
Obliged.
Lordship may
Please
retain the
oblige,
old
my
order.
lords.
Obliged.
Lordship
Deeply
may retain
obliged.
the old order. Lordship may retain the old order.
Yes.
Yeah, it is. Obliged.
Lordship may kindly have page 80.
Page?
80. 80.
What? What is the matter?
It is a matter with regard to amputation of the right leg from the loin, in between the loin. Lordship may kindly see page 80.
Who is for the respondent?
My lords, I am appearing for the respondent, my lords.
It's complete. Long time back.
Yes.
It's a matter filed in 21.
Lords,
Yes.
I am
Already 21 years have passed and 17.
Tuesday, some Tuesday will hear this.
even otherwise, your lordship judgment is in accordance with the pronouncement of this honorable court. It's 2004
Yes.
accident, rightly given as per the law prevailing there.
Yes.
40% future prospects.
24th March. Tuesday.
24th March. Highly obliged.
Very good. Taking some time to file rejoinder. Rejoinder, can I be allowed to?
Rejoinder?
Please, ma'am.
Counter has come.
Counter has come by the insurance company.
How much time?
4 weeks.
4 weeks only.
6 weeks.
Rejoinder. This is the rising out of some amnesty.
Frequently, my lord, housewife, her right hand has been amputated, my lord. 7 lakhs is common.
Anyway, as you wish, 4 weeks.
Wait.
Yes. Yes.
This is a MSCT matter, my lords.
All MSCT coming at the fag end.
It may be listed on some Tuesday.
After notice matter.
After notice matter, counter.
Counter, rejoinder, everything is on record. Rejoinder not required.
Not, my lords. We have filed additional documents. We will rely on that.
Some additional amount you are seeking.
My lords, what had happened?
This is by claimant, owner, what?
MSCT had given 4,29,000.
By claimant. This appeal is by claimant.
Yes. However, High Court made it 0, my lords.
0?
Yes.
Oh. Why 0?
Basically, my lord, that accident has occurred in the year 1999.
So 1999 accident, no compensation.
No, my lord. Unfortunately, that he has died out of in the year 2001 after more than approximately 2 years. So he is seeking. He is seeking
Court says death is not on account of the accident.
Right, my lord.
It is natural death.
No. High Court has taken everything on record. I mean, considered the evidence on record, my lord. There
is no connection between
no conclusive. Yes.
Death of the deceased and
Yes,
the accident he suffered 2 years back.
Yeah, no document has been filed by them, my lord, regarding that medical certificate. Nothing is there on.
He was in hospital for 2 years.
No, my lord.
No, my lord. He was only.
Crushed, my lord. It has come
He was-
evidence, and he was not able to do his daily affairs, my lord.
He was only 29 days he was
It's a
there.
difficult case for you.
My lord, so it
Appears to be.
appears that's why my lord said to you.
Yeah. Post on 7th April.
Grateful, my lord.
My lord, if I may be allowed to give physical appearance in item 16.
Physical limit.
Below in item 46, I'm seeking accommodation below.
Yes, 4 weeks. Yes.
Careful.
My lord.
Yes, my
Item
lord.
20. Again, Council Anil Singh Nishani sir has went to cremation of Amit Tiwari sir's son. So pending grant short of accommodation.
Which matter?
Item 20. It was dismissed by
20.
I was asked to take short accommodation.
Item 20 क्या किया है? Dismiss कर दिया. Why?
Dismissed.
Oh, Lalithamma, yes, twice you have taken adjournment.
Short accommodation.
And this is third time.
Sir has went for cremation of.
Sir has?
Sir has went for cremation of Amit Tiwari's sons.
कर दो भाई इनके सर निकाल देंगे ना.
अनिल सिंह.
आइटम 20 में डिसमिस नहीं करना. मिली लिए शायद ने. Monday. Coming Monday. है ना?